CRW2602, Learning Unit 2, Crimes Against the Administration of Justice. Learning Outcomes. When you have finished this learning unit, you should be able to demonstrate your understanding of the requirements for certain crimes relating to the administration of justice by considering the possible liability of an accused for the crimes of common law, perjury, statutory perjury, defeating or obstructing the course of justice, and contempt of court. Perjury at common law. Read on Criminal Law Prescribed Book pages 332 to 335. Definition. Perjury at common law consists in the following: unlawful, intentional making of a false declaration under oath, or in a form allowed by law to be constituted for an oath in the course of a legal proceeding. Elements of the crime. The elements of this crime are: 1. The making of a declaration. 2. Which is false. 3. Under oath or in a form equivalent to an oath. 4. In the course of a legal proceeding. 5. In an unlawful. And 6. Intentional manner. False declaration. This requirement comprises the following: 1. The declaration must be objectively false. In English law, only subjective falsity is required. Subjective falsity means that the crime is committed even when someone speaks the truth while believing that he is telling a lie. Our courts, however, have never yet decided that the crime can be committed in this manner. Section 101, subsection 1 of the Criminal Procedure Act assumes that an objectively false declaration is required. 2. The declaration may be oral or in writing, in an affidavit. 3. The falsehood may be made either expressly or impliedly. If it is made impliedly, the prosecution relies on an innuendo. In Valab 1911, for example, it was decided that the words of a witness, "I have already stated what I heard," implied that the witness had heard nothing more. If the prosecution relies on an innuendo, the implication that it relies on must be necessary implication and must be based on evidence led at the trial itself and not on extrajudicial declarations. Under oath or in a form substituted for oath. The declaration must be under oath or in one of the forms allowed to be substituted for an oath, namely an affirmation to tell the truth or a warning by the presiding official to the witness to tell the truth. For the benefit of those students who have not yet passed a course in criminal procedure or who are unacquainted with court procedure, we would like to explain the previous statement. There are 3 ways in which, before commencing this evidence, a witness can undertake to speak the truth. 1. The most common method is taking an oath, that is, swearing that he will speak the truth. Section 162 of the Criminal Procedure Act. 2. A person may declare that he solemnly confirms that his evidence will be the truth. Section 163 of the Criminal Procedure Act. This happens when an intended witness objects to taking the oath, perhaps on religious grounds, or indicates that he does not regard the oath as binding on his conscience. 3. Young children are merely warned, usually after a friendly little sermon by the magistrate or judge, to speak the truth. Section 164 of the Criminal Procedure Act. For the purposes of criminal law, it is important to remember that a witness who intentionally makes a false statement commits perjury, even if his statement is not under oath, but merely made after an affirmation in terms of Section 163 to speak the truth, or after being warned in terms of Section 164 to speak the truth. This rule is specifically set out in Section 163 subsection 2 and Section 164 subsection 2 of the Act. Because only a declaration under oath or its equivalent can form the basis of perjury, the crime cannot be committed, for example, during argument to the court by a legal representative. The person who administers the oath or its requirement, e.g. the magistrate, must have the authority to do so. In the course of a legal proceeding, subtopic, the crime is only committed if the false declaration is made in the course of a legal proceeding. Extrajudicial false sworn statements are also punishable, but not as common law perjury. They can be punishable in terms of Section 9 of Act 16 of 1963. An extrajudicial statement is a statement made outside the court concerning a matter which has nothing to do with the dispute decided in court. The legal proceeding can be either a criminal or a civil case. False sworn statements are made before an administrative tribunal do not constitute the crime. Thus, it was held that such a declaration at a meeting of creditors in terms of Insolvency Act cannot amount to perjury. Cass 1967. In Bookman 1950, it was decided that perjury can be committed by making of a declaration outside the court or before a case has begun, provided that 1. Such declaration be permissible as evidence at the subsequent trial. 2. The maker of the declaration foresees the possibility that it may be used subsequently in a trial. According to this test, therefore, perjury can be committed by making a false affidavit for the purposes of a civil motion proceeding, which is mostly in writing, but not by making a declaration in which a false criminal charge is lodged, or by making extrajudicial sworn statements to the police during the investigation into a crime. Bookman 1950. In the Bookman case, it was decided that extrajudicial statements made to a police officer are not normally used in the subsequent trial as evidence, and consequently they are not declarations made during a legal proceeding. The fact that the false declaration is made during a case, the judgment of which is later set aside on appeal, is no defense. The position is the same if the warrant for arrest of the accused was invalid. 2.1.6 Unlawfulness. The fact that shortly after making a false statement, e.g. in cross-examination, the witness acknowledges that the statement was false and then tells the truth is no excuse. Also, the fact that the false declaration was made by X in a vain attempt to raise a defense is no excuse. This happens in our courts daily, but for practical reasons, not every accused whose evidence is rejected as false is afterwards charged with perjury. Malianga 1962. 2.1.7 Intent. X must know or at least foresee the possibility that his declaration is false. Mere negligence or carelessness is not sufficient. Mukwena, 1984. 2.2 Statutory perjury. Read on Criminal Law Prescribed Book, page 336 to 338. Definition. Statutory perjury at common law consists in the unlawful, intentional making of two conflicting declarations under two different oaths, or in any form allowed by law to be substituted for an oath. Elements of the crime. The elements of this crime are: 1. The making of two declarations. 2. Which are conflicting. 3. Under two different oaths or in any form equivalent to an oath. 4. In an unlawful, and 5. Intentional manner. 2.2.3 Content of section. This crime is set out in section 319 subsection 3 of Criminal Procedure Act 56 of 1995 as follows. If a person has made any statement on oath, whether orally or in writing, and he thereafter on another oath makes another statement as aforesaid, which is in conflict with such first mentioned statement, he shall be guilty of an offense and may, on a charge alleging that he made the two conflicting statements, and upon proof of those two statements, and without proof to which of the said statements was false, be convicted of such offense and punished with penalties prescribed by law for the crime of perjury, unless it is proved that when he made each statement, he believed it to be true. This statutory offense was specifically created for persons who have escaped convictions of perjury, even though they made false declarations under oath. If X made two conflicting statements under two different oaths, he could only be convicted if the state proved that one of the statements was false and that X knew it was false. This is often very difficult to prove. When prosecuting a person for contravening of this subsection, the state only has to prove that A. X on two different occasions made two statements under oath, and B. The statements conflict with each other. 2.2.4 Two statements under oath on two different occasions. It is immaterial whether one or both oaths are in writing or oral. Neither does it matter whether either was made in the course of a legal proceeding, although at least one of them usually is. Mohammed, 1951. The crime is also committed if the conflicting statements are made in any form allowed by law to be substituted for an oath, such as an affirmation or declaration to speak the truth. Making conflicting statements under the same oath does not constitute the crime. The state must also prove that the oath was administered in accordance with all regulations and that the person administering the oath had the necessary authority to do so. 2.2.5 The statements conflict with each other. The state needs to prove which statement is false, only that they conflict. Mohammed, Supra 442. In Ramdas, 1994, the Appellant Division held that the conflict in the two statements must be clear, taking into account the context and surrounding circumstances. The two statements must be reconcilable and must be mutually exclusive. If the second statement consists in only a denial that the first statement was made, there are two conflicting statements. Remember that the difference between perjury and statutory perjury is that for the crime of perjury to be committed, one false declaration must be provided under oath in a legal proceeding, while in statutory perjury, the accused made two different statements under oath on two different occasions, and these statements conflict with one another. 226. Onus on accused. The onus falls upon X to prove on a balance of probability that he believed in the truth of each statement at the time when he made each one. It is submitted that this reverse onus is unconstitutional, since it conflicts with Section 35, subsection 3, paragraph H of the Constitution, which grants X the right to be presumed innocent. 2.3. Defeating or obstructing the course of justice. Read on Criminal Law Prescribed Book, pages 327 to 331. Definition. The crime of defeating or obstructing the course of justice consists in unlawfully and intentionally engaging in conduct which defeats or obstructs the course of administration of justice. 2.3.2 Elements of the crime. The elements of this crime are 1. Any act which 2. Defeats or obstructs the course of justice. 3. In any unlawful, and 4. Intentional manner. 2.3.3 Defeating or obstructing the course of justice. This is a very important crime which is often committed in South Africa and may overlap with many other crimes such as contempt of court, perjury, fraud or forgery, extortion, obstructing the police in the course of their duties, and being an accessory after the crime, after the fact to another crime. Although there has been confusion as to the naming of the crime in practice, it is submitted that defeating or obstructing the course of justice represents the most correct designation. There is a difference between the terms defeating and obstructing. Obstructing means something less than defeating. X can only be found guilty on a charge of defeating ends of justice if it is proved that justice has in fact been defeated, as for instance where an innocent person was wrongfully convicted. As it is usually difficult to prove that the course of justice has in fact been defeated, it is common to charge conduct falling within the ambit of this crime as defeating or obstructing the course of justice or attempting to do so. 2.3.4 Examples of conduct. The following are examples of behavior amounting to defeating or obstructing the course of justice. 1. Unlawfully inducing or attempting to induce a witness to give false evidence. 2. Refusing to give evidence. 3. Giving false information to the police. 4. Soliciting a complainant by unlawful means to withdraw a charge. 5. Soliciting a prosecutor by unlawful means not to prosecute. 6. Trying to influence the judiciary by pressuring them not consider certain types of evidence. 6. Tampering with court documents in order to prevent true evidence being placed before court. If a motorist warns other motorists of the presence of a speed trap by flashing his lights, he commits an attempt to defeat the course of justice, as decided in Naidu 1977. However, in Pereira 1978, a case with identical facts, it was held that X will be guilty only if he has reason to believe that the vehicle approaching him is exceeding the speed limit or that the driver of this vehicle has the intention of exceeding the speed limit. It is submitted that the latter approach is preferable. 2.3.5 Possibility of court case ensuring. The crime may be committed even though there is no pending case. However, there must be the possibility of a real court case ensuring. For example, where X makes a false complaint at the police station accusing Y of having committed an offense, there is the possibility that Y may be charged with the alleged offense and X has therefore committed the crime. The concept, course or administration of justice, which must be obstructed, refers to a process which is destined to end in a court case between parties or between the state and its subjects. In Buzzard 1992, the accused phoned the police and declared that he had kidnapped an unknown girl and that he would kill her if a certain amount of money was not paid as ransom for her. Because of the call, the police conducted a search and located the accused, who informed them that the report was false and that no girl was in fact kidnapped. The accused was subsequently charged with defeating or obstructing the course of justice. The court held that X's conduct in making a false report to the police to the effect that he had kidnapped another person was not punishable as obstruction of justice because it amounted to a mere wasting of time of police officers and therefore did not interfere with the course of administration of justice. The accused did not attempt to bring another innocent party into trouble or commit the conduct in order to conceal another already committed crime. He merely wasted the police's time and energy. In this case, no real court case was destined to ensure, as no actual kidnapping had in fact taken place. The facts in Buzzard must be distinguished from a factual situation such as the following. X, who was intoxicated while driving a motor car, collided with a child who was playing in the street. He drove away without having reported the incident to the police. Instead, he went to the police station and reported that his car had been stolen. The police investigated the matter and found out the truth. X can be convicted of the crime of obstruction of justice because the hit-and-run incident could have led to an actual court case. X could be charged with an offense for failing to report the accident. 2.3.6 Intention. X must subjectively have foreseen the possibility that his conduct might defeat or obstruct the administration of justice. He must have been aware of the fact that it might interfere with judicial proceedings which were to take place in the future or would at least hamper the investigation of an offense. 2.3.7 Attempt to defeat or obstruct the course of justice. If X intentionally gives the police or a witness false information which is, however, immediately disbelieved or acted upon, he neither defeats nor obstructs the course of justice, but his conduct will constitute an attempt to defeat or obstruct the course of justice. Charges of attempting to defeat or obstruct the course of justice are, in fact, more common than charges of having committed the completed crime. 2.4 Contempt of court. Read on the Criminal Law Prescribed Book, pages 315 to 327. Definition of contempt of court consists in the unlawful and intentional 1. Violation of the dignity, repute, or authority of a judicial body or a judicial officer in his capacity. Or 2. The publication of information or comment concerning a pending judicial proceeding, which has the tendency to influence the outcome of the proceeding or to interfere with the administration of justice in that proceeding. 2.4.2 Elements of the crime. The elements of this crime are the following. 1. A. The violation of dignity, etc. of the judicial body or the judicial officer. Or B. The publication of information or commentary concerning a pending judicial proceeding, etc. 2. In an unlawful, and 3. Intentional manner. 2.4.3 Unusual characteristics. The crime manifests the following unusual characteristics. 1. The act by which the crime is committed can be divided into various groups, some of which have very distinctive requirements, e.g., the requirement that a case must be sub judice, that is, the legal process has not been yet completed in the case of publication of information, which is potentially prejudicial to the just trial of a case. The crime can therefore be subdivided to a certain extent into several sub-crimes, each of which had certain distinctive requirements. These particular forms of the crimes will be dealt with in 2.4.9 below. 2. As a rule, some cases of contempt of court are not even treated as criminal cases, but as civil cases in the civil courts. However, it has been held that these cases can also come before the courts as criminal cases at the same time, if the Director of Public Prosecutions chooses to bring the case before a criminal court. These cases are discussed in 2.4.9.2b below. 3. Some cases of contempt of court are heard according to an unusually drastic procedure. See 2.4.5 Contempt in Face Curae below. 2.4.4 Reasons for the existence of crime. Contempt of court is punished not to protect the dignity of an individual judicial officer only, but to protect the administration of justice. The violation of the dignity and repute of a judicial officer undermines the respect of the public for the court and the administration of justice, and consequently the whole legal order. Van Niekerk, 1972. In the case of contempt committed by the publication of information or comments on a pending case, the reason for the crime is that the court should come to a decision only on the grounds of permissible evidence before it, and ought not to be influenced by the disclosure of facts or comments from outside, such as those in the press. 2.4.5 Acts. We distinguish between contempt in face curae and contempt ex face curae. In face curae literally means in the face of the court, and contempt in this form is contempt in the presence of the judicial officer during a session of the court. In cases of contempt in face curiae, the court has the power to convict the wrongdoer summarily and sentence him. This power is undoubtedly necessary to place the court in a position to maintain its dignity, but our courts have frequently stressed that this drastic procedure must be applied with great caution. Ngemu, 1964. The judicial officer in these cases is complainant, witness, and judge all at the same time. The accused is normally undefended, and trial usually takes place in an emotionally charged atmosphere. Contempt of a lesser nature can best be ignored. Ngomezulu, 1972. And a request to a wrongdoer to offer his apologies to the court, followed by such an apology, can often maintain the dignity of the court without the person being sentenced for contempt. In Lavenga, 1966, in Lavenga, 1996, the court held that punishing an accused for contempt of court in face curiae is not unconstitutional, insofar as the rules relating to this form of the crime infringe upon certain rights of the accused, such as his right to a fair trial and his right to legal representation. Such infringement is, according to the court, justified. Contempt ex face curiae occurs through actions or regards out of court and can take a variety of forms, such as 1. Scandalizing the court by the publication of allegations which, objectively speaking, are likely to bring judges or magistrates or the administration of justice through the courts generally into contempt, or unjustly to cast suspicion on the administration of justice. State versus Mamabolo, 2001. 2. Failure to comply with a court order. 2.4.6 Unlawfulness. 1. Statements by members of certain bodies such as the Legislative Assembly, when present in the Assembly, are privileged and cannot amount to contempt. See, for example, subsection 58 and 71 of the Constitution of the Republic of South Africa. 2. Of importance is the rule that fair comment on the outcome of a case or on the administration of justice in general does not constitute contempt of court. Public debate on the administration of justice is, in fact, not only permissible but also desirable in a community such as ours to ensure that law and administration of justice enjoy the respect of the population. The famous words of Lord Atkin in Amperd versus AG of Trinidad, 1936, have been quoted with approval by our own courts, e.g. Van Niekerk, 1970. Justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respect, even though outspoken comments of ordinary men. There is, for example, nothing wrong with a newspaper complaining that certain sentences are too light or too heavy, provided that the comments are made bona fide, in reasonable terms and in the interest of the proper administration of justice. On fair comment as a ground of justification, see Van Niekerk, Sopra, 656 to 657. 2.4.7 Intent. In general, intention is an essential element of the crime. Van Niekerk. Except in cases where the editor of a newspaper is charged with this crime on the ground of the publication in his newspaper of information concerning a pending case, which tends to influence the outcome of the case. Culpability in the form of negligence will be sufficient to establish contempt of court in such circumstances. See the discussion below of contempt of court in the form of commentary on a pending case. However, remarks in a newspaper article, for example, must be read in context in order to establish the presence of intent. To request a judicial officer bona fide and in courteous language to withdraw from the case, for example, on an account of his personal knowledge of the event, does not constitute contempt. If X's apparent offensive action is attributable to forgetfulness, ignorance, absent-mindedness, or negligence, intent is lacking. Nene, 1963. 2.4.8 Administration of Justice by the Courts. The language complained of must be directed at the judicial officer in his judicial capacity or at the administration of justice by the courts. Criticism of the performance of a mere administrative function like the actions of the police or criticism of alleged unreasonableness in acts of parliament is not contempt of court. Dlamini, 1958. In Nyikala, 1931, X said to a magistrate, "Because I'm a native, I'm always considered guilty." On closer investigation, it appeared, however, that his words referred to the methods of the police. He was found not guilty of contempt. Encouraging the public to sign a petition for the reprieve of a person who has already been sentenced is not contempt. In Trump, 1966, the court declared that mere criticism of the prosecution in a criminal case is not contempt of court either. 2.4.9 Some examples of the crime. Contempt in face curiae. Examples of such contempt in the open court are: 1. Shouting at witnesses during cross-examination. 2. Illegal representative's conduct of a case under the influence of alcohol. 3. Continual changing of one's seat and talking loudly in court. 4. Grabbing and tearing a court document to pieces. On the other hand, in Nyalamisa, 1993, the court held that merely falling asleep in court does not necessarily amount to contempt in face curiae, since it merely amounts to a trivial breach of court etiquette. There must be intent to violate the dignity of the court. In Kupelo, 1961, for example, X loudly sang a religious song while she was leaving the courtroom after the conclusion of a trial. Her conviction of contempt of court was set aside on review because it appeared that she had misbehaved in such a way merely out of joy that she had been acquitted, and not to insult the magistrate or the court. In the State versus Meyring, 2019, the court held that audibly uttering swear words in court does not amount to contempt of court in face curiae. When his case was postponed for a third time, the accused audibly uttered obscenities, expressing his frustrations. In these circumstances, the court did not find his conduct unseemly behavior. 2.4.9.2 Contempt ex face curiae. Examples of a few circumstances in which contempt ex face curiae can be committed are: 1. Where a person pretends to be an officer of the court, such as an advocate, attorney, or deputy sheriff. 2. Where someone intentionally obstructs an officer of the court, such as a messenger of the court in the execution of his duties. 3. Where someone bribes or attempts to bribe a judicial officer, legal representative, or witness. 4. Where a witness who has been summoned deliberately fails to appear at the trial. 5. Commentary on pending cases. 6. Scandalizing the court. And 7. Failure to comply with a court order. A. Discussion of commentary on pending cases. The crime is also committed by publishing information or commentary calculated to influence the outcome of a case that is still sub judice. The expression means that the matter is still under consideration by the court. Of course, the press is fully entitled to publish the evidence delivered in the course of the trial, or portions thereof. However, the press may not, while the case is still in progress, publish information relating to the merits of a case which did not form part of the evidence in court. A journalist may not, for example, publish information or opinions concerning the case which he heard outside the court during an adjournment of the court for tea. Neither may he give his own opinion regarding the guilt or nor otherwise of the accused, or draw his own inferences from the evidence before the court has been concluded. The underlying reason for prohibiting the publication of such information is to avoid so-called trial by newspaper. The judge, assessors, or magistrate should not be influenced by information or commentary emanating from sources outside the court. A case is sub judice from the moment that it commences with the issue of a summons or with an arrest, until it has reached its final conclusion in the judicial process, and that includes the last possible appeal. The test for ascertaining whether the publication is calculated to influence the outcome of a case is extremely wide. It does not matter whether or not the publication has ever reached the ears of the court, and if indeed it has, whether or not the court believes the facts contained in the publication, or has allowed itself to be influenced by them. It does not even have the probable that the words may influence the court. Van Niekerk, 1972. Hot topic. The rules pertaining to contempt of court ex face curiae are being challenged by the rapidly changing media environment. Think, for example, by the highly publicized case of the State versus Pretorius. In Multi-Choice Limited and others versus National Prosecuting Authority and others, the Pretoria High Court had to decide whether the entire Pretorius criminal trial would be broadcasted, taking into consideration the constitutional right to freedom of speech as well as Section 34 and 35 subsection 3 paragraph C of the Constitution, which require that legal proceedings, that is criminal proceedings, be accountable, transparent and open to the public. It was held that broadcasting must be allowed. In the light of this decision, do you think that commentary on pending cases is still a crime? Liability of a newspaper editor. The administration of justice may not be privileged or interfered with, or else the crime of contempt of court is committed. A publication will be unlawful if there is a risk that the prejudice will occur if publication takes place and substantial prejudice may be caused. Mere speculation is insufficient. In MIDI Television 2007, it was held that the exercise of press freedom has the potential to cause prejudice to the administration of justice in various ways. This prejudice can be caused through the conduction of trials through the media, prejudging issues, or the application of pressure on judicial officers or witnesses. It has to be determined whether the risk of prejudice is such that it will interfere with the administration of justice. The court would also have to evaluate and be satisfied that by limiting the publication of information, the advantage in so doing would outweigh the disadvantage. The extent of limitation imposed on the right and the purpose, importance and effect of the intrusion will need to be weighed. For some time, there has been uncertainty on our law whether intention is required for a conviction where an editor of a newspaper has been charged with contempt of court on the ground of having published information in his newspaper concerning a pending case which tends to influence the outcome of the case. In Harper 1988, the Appellate Division removed this uncertainty by holding that it is not necessary to prove intention in these cases, since in cases such as these, the culpability may consist of either intention or negligence. The editor would be negligent if the reasonable person in his position could foresee that the information which he publishes might deal with a pending case or that it might scandalize the court. The rule that negligence may be a sufficient form of culpability is based on the consideration that since the press influences public opinion to such an extent, it correspondingly shoulders a heavier responsibility than the ordinary individual to control the correctness of what it publishes. However, the rule that these cases proof of intention is no longer necessary and that proof of negligence is sufficient applies only if the editor or proprietor of a newspaper or magazine or the company which owns it is charged with a crime. The rule does not apply where an individual report is charged in his private capacity. Please remember that for a conviction of contempt of court ex face cure of a journalist, proof of intention is required. However, for a newspaper editor, negligence is a sufficient form of culpability. Also note that culpable homicide and this form of contempt of court are the only two exceptions to the rule that intention is the form of culpability required for all common law crimes. In the case of the two exceptions, negligence is required. Activity. Why a well-known politician appears in court on charges of corruption. A reporter at a daily newspaper, X, attends the trial on a daily basis. He reports on the trial, but also undertakes his own investigation by interviewing previous employers of Y. He writes in the newspaper that Y was previously in the employ of a company where he embezzled money. He writes this article in such a way that it looks as if this piece of information was presented as evidence before the court. In actual fact, a previous employer, B, had told him, X, about the embezzlement incident. This piece of information was never put before the court as evidence in the trial. The newspaper editor Z and the reporter X are both charged with contempt of court in that they published information that had the tendency to influence the outcome of the trial. The legal representative of the newspaper editor argues that the editor Z was unaware of the unlawfulness of the conduct in question. The reporter X had misled him by telling him that the state had called B as a witness and that he, B, had testified about the alleged embezzlement incident. Z's legal representative argues that because Z, the editor, lacked the intention to influence the outcome of the case, he should be acquitted. However, in cross-examination, the editor told the court that the specific reporter X had on numerous occasions in the past embarrassed him by not disclosing his true sources. Z, the editor, had to publish many apologies in the newspaper to avoid legal action being taken by aggrieved parties. You are the state prosecutor. Discuss how you would go about proving that both X and Z had the required capability to be convicted of the offense. Feedback. The form of culpability required for contempt of court differs, depending on whether a reporter, a newspaper editor, or a proprietor of a newspaper is charged with the crime. Whereas intention is the required form of culpability for the liability of a reporter, mere negligence is a sufficient form of culpability in the case of an editor or proprietor of a newspaper. The reasoning behind this is that the press is such a powerful instrument in influencing public opinion that the owner of a newspaper or the person in charge of the newspaper, that is the editor, has a heavier responsibility than the individual reporter for controlling the correctness of what is published. X, the reporter, may be convicted of the offense if you, as state prosecutor, prove beyond reasonable doubt that he, X, intended to create an impression in this report that the alleged embezzlement was presented as evidence at the trial and that he knew or foresaw that the publication could have tended to influence the outcome of the trial. As regards the liability of the editor of the newspaper Z, you should have relied on the case of Harper, arguing that the state only has to prove that he was negligent. You should have pointed out that the editor himself had stated in cross-examination that X, the reporter, had previously misled him about his sources of information. In other words, you should have argued that the editor was negligent because a reasonable editor in his position would have realized that X, being an unreliable reporter, might again have lied about his source of information, that a reasonable editor would have taken steps to control the correctness of Y's reporting and of X's reporting and that Z had failed to take such steps. B. Scandalizing the court. Read on Criminal Law Prescribed Book, pages 322 to 324. This form of contempt can be committed without there being any pending case. The crime is committed by publication, either in writing or orally, of allegations which, objectively speaking, are likely to bring judges, magistrates, or the administration of justice through the courts generally into contempt or unjustly to cast suspicion on the administration of justice. Mamabolo, 2001. Whether the administration of justice was in actual fact brought into disrepute is irrelevant. All that is required is that the words or conduct should have the tendency or likelihood to harm. It does not matter whether the attack is directed at the particular judicial officer or at the administration of justice through the courts generally. To constitute contempt, an attack on an individual judge need not necessarily be made in public. It is also committed if the judge is slandered in his judicial capacity in a private communication to him, e.g. a letter, even though no third party is aware of the communication. Examples of this form of crime are 1. The imputing of corrupt or dishonest motives or conduct to a judge in the execution of his or her judicial duties. 2. The improper arousing of suspicion regarding the integrity of such administration of justice. In State v. Moyler, 2005, the accused X published press releases and letters to all and sundry over a period of more than a year, in which he leveled accusations of bias, racism, incompetence, intimidation, collusion, lack of integrity, and impartiality against judges. He also called for the recusal of the entire Transvaal provincial division of that time. The accused raised the defense that the publications were made in exercise of his right to freedom of expression. He was charged with contempt of court ex face curiae in the form of scandalizing the court and was convicted of this crime. The court held that the comments that he had made were not fair and reasonable, were not made bona fide, were not true, and were not in a public interest. The accused had acted in malice and deliberately abused his right to freedom of expression to savage the character and integrity of the judges concerned in their capacities as judges. The court further held that the publications were likely to damage the administration of justice were unlawful, and that X had acted with dolus eventualis, in that he subjectively appreciated that it might cause harm to the administration of justice, but he continued to do so, reckless as to whether or not such harm eventuated. C. Failure to comply with a court order. Read on the prescribed book, Criminal Law, page 325. A party to a civil case against whom the court has issued an order and who deliberately fails to obey the court order commits contempt of court. As a rule, such a party is not criminally prosecuted for contempt, but it is left to his successful opponent, if he so chooses, to apply to the court to sentence the party who fails to carry out the court order for contempt. Such an application is usually only a method of enforcing the court order, because if the request is successful, the sentence is, as a rule, suspended on condition that the court order is carried out. Note versus Tuck, 1968. These cases are known as civil contempt. In practice, this procedure is regularly followed by a person who has been divorced and who wants to force the other party to the divorce to comply with the order of court relating to the payment of maintenance. In Bayers 1968, the Appellate Division decided that in such cases, there is nothing preventing the Attorney General himself from charging and prosecuting the party who fails to carry out a court order. The court decided that in civil contempt, it is still a crime that is committed even though the case is heard by a civil court, because in these cases, a sentence is always imposed, and no sentence can be imposed if no crime is committed. Moreover, if the Attorney General had not had the power to interfere, it would have meant that the most far-reaching contempt of court would remain unpunished if the successful litigant decided for some reason or other not to request enforcement of the order. In failing to comply with the court order, intent must be present. In the State v. Samuels 2016, the accused admitted that she disobeyed a court order evicting him from an informal dwelling on state land, but stated that she had nowhere else to go. The court concluded that she did not have the necessary intention, deliberately and malafide, to disobey the court order. We come to the end of this learning unit.